Okay. Thank you both for your presentation and for a very interesting paper, which to me really presented a very thorough and profound historical description of the intellectual growth regarding this discussion of who is actually at the core of international law, whether it's the state or the individual. It's actually quite interesting to challenge that perception we typically have that this period after the Second World War is in fact a crucial one, when in fact you clearly show that things happened even before in the interwar period. And what's really fascinating about your description was that this intellectual development happened across disciplines. I mean, it's not just the legal scholars, you present also philosophers, sociologists, and so on, and pretty much across the world also. I mean, it's not in a particular country or in a particular region. You see it in the U.S., in Europe, and continent, and so on. So that's very interesting. In a way, it makes sense, because what we have in this interwar period is a kind of a junction between two things that often foster intellectual development. One is it's a period of construction and reconstruction, right, of states, of borders, of citizenship, of belonging, of membership. And on the other hand, it's also a period in which exceptional crisis-like phenomena of statelessness with their social marginality and everything occur. And in this junction between these two phenomena, we see that often intellectual growth happens. I mean, it's something that we also see in a much later period in the 70s and in the 80s in Europe, with the waves of migration and changes in several countries. Some philosophers and sociologists also thought that this reconstruction of state boundaries, membership, and so on, call for a change in thinking of how we perceive citizenship, what we think the role of states are, and so on. And to me, as someone who studies immigration, I think these points of change and these locations of social marginality are the most interesting points, because they tell us so much about the general context of our thought, about how we perceive fundamental aspects of society, about how we think about the general role of states in the world, and so on. Now, I want to make 2 points. One has to do with your description of what happens in the interwar period. You call the intellectual insights gathered throughout this period as cosmopolitan. And what you describe is a general trend of movement towards alternative solutions to that of the state, to wider bases of solidarity. I do wonder, though, if you can actually describe it as cosmopolitan, in the sense that would those scholars in the interwar period actually suggest that states need to, or international law needs to, intervene with situations that occur and touch people who are still within their states, who have not migrated, who still have the official citizenship status? What I'm trying to basically ask is whether the thought of the place of the individual within international law through this lens of statelessness did not limit kind of the imagination or the thought process of this intellectual change, and if people were able to think about a comprehensive theory about the role of the state that goes beyond the case of citizenship to other cases of human rights infringements that do not involve crossing international lines, losing the formal status of citizenship, and so on. My second point takes me back to my territory, and that's the territory of refugees. Now, your paper deals obviously with statelessness, and I think it really begs a comparison to the situation of refugees, mostly because they're just very similar. Waves of movements of refugees and statelessness occurred in the world pretty much around the same historical circumstances, around the same times, quite often around the same crises, of people from the same nationalities. Now, with refugees, we know that historically states did not resist in allowing refugees to enter them, and were quite kind to refugees in the first few decades. But at some point, we usually talk about the interwar period, states started showing some reluctance to taking in refugees. Now, the intellectual discourse on refugees it's possible to read it in two ways. Now, there's the optimistic reading, according to which the discourse on refugees is a discourse which puts the refugee in the middle and kind of overlooks its connection to the state of origin, and puts forth the human rights of the refugees over sovereignty in two ways. First of all, it does not respect the sovereign decision of its state of origin to persecute a person, and then it also does not respect the fact that the state of asylum has the authority to deport a person or exclude a person, but rather it imposes some obligation on that person, on that state, sorry. Now, I do have to say that with respect to refugees, most solutions that were thought of, even in the interwar period, were based on the fact that states incorporate refugees, and other solutions of neutral territories where refugees will find asylum and so on were pretty anecdotal throughout time. And kind of the basic presumption, even early on, was that people need surrogate protection. When they can't get protection from their state, they need it from a different state. And that's really interesting to compare, because what you describe in the 20s is a completely different attitude towards stateless persons. So that's the first reading, a more optimistic reading. The second reading, which is a more cynical reading of the thought process regarding refugees, says that state had interest in developing legal regimes to deal with refugees so that they can exclude them. James Hathaway, who's one of the prominent scholars in this field, basically says that the entire legal infrastructure of refugee law was designed as such that does not protect human rights, but rather takes into account the interest of a state and allows the state to exclude people who don't meet a very narrow set of criteria. Now, in light of this, I wonder, I have two questions actually. First of all, if you take into account the cynical reading of refugee law and maybe try to apply it to the context of statelessness, is it possible to think that the intellectual development between the two world wars that focused on the thesis that the state is not the main actor actually was useful for states to refrain from granting protection to stateless persons, or granting status or rights to stateless persons? And my second question is, can we also think about the intellectual growth after the Second World War as something that you can explain in a similar manner? I mean, you mentioned this in your presentation now and also in the end of your paper, and that the option of imposing a great number of stateless persons on states was denied, and that gives us a good indication that maybe was taken into consideration as part of the thought process. If that's the case, then what happened after the Second World War not only steps away from what you call the cosmopolitan angle, but also steps away from the liberal commitment to human rights and from the perception of states as trustees of humanity.